So we're going to continue with Part 1, Code Administration, Chapter 2, the legal aspects, permits, and inspections.
Legal aspects, permits and inspections. Building codes intend to protect the health, safety and welfare of the public by establishing minimum acceptable standards of construction. In order to be effective, such codes must be legally adopted by the governmental jurisdiction and enforced by qualified officials appointed by the governing authority. This chapter explores the process of adopting, amending, and administering the International Residential Code (IRC), but the principles generally apply to the other international codes as well. Code adoption. IRC and the family of international codes are referred to as model codes, nationally recognized construction regulations that serve as models for local ordinances, and are typically adopted by reference. International codes are maintained and updated through an open process of code development. Such a process relies on the participation of experts and all interested parties in the various fields of design, construction, manufacturing, government and code administration. THSA model codes are updated on 3-year cycles to recognize new and developing technology, materials, and methods of construction. Changes in the codes are also often in response to natural or human-made disasters involving the loss of lives or the destruction of property. Adoption of the IRC becomes an enforceable regulation through the legal proceedings of the governmental jurisdiction. Adopting ordinance references the addition and title of the IRC and provides other necessary factual information, figure 2:1. Typically the legislation also includes the purpose, scope, and effective date for the ordinance. As part of the adoption process, the government authority must also provide local information for insertion into code text, including the name of the jurisdiction, design criteria, see Chapter 4, and building sewer depths, see Chapter 13. Ref. R101.1, Table R301.2, 1, P2603.5.1. Amending the IRC. Advantages to the adoption of model codes include consistency, uniformity, and correlation among construction codes and across jurisdictional boundaries. Such uniformity benefits designers and builders as well as government officials in charge of administering the codes. Although states, cities, counties, and similar governmental jurisdictions typically do not have the resources to develop and maintain comprehensive construction codes, jurisdictions do have the ability to modify the model code through amendments placed in the adopting ordinance. Excessive local amendments to adopted model codes may be contrary to the goals of consistency and may offset the advantageous and legal defensibility of nationally recognized standards. Still, some modification of the IRC may be necessary or desirable for any number of reasons. Though model codes anticipate location and climate differences, amendments to them may be influenced by unique characteristics and conditions, such as geographic location, weather, topography, flooding, soil properties and water tables. There also may be considerations of political influences, local traditions or customs, compatibility issues with other state or local laws, or the existence of unique housing stock, such as in historic districts. It is important to recognize that these amendments must be legally instituted with care through the adopting ordinance and laws of the jurisdiction. Otherwise, actions to enforce provisions not contained in the IRC or to waive certain requirements that are in the model code, in addition to creating inconsistency in the application of the code, will not be in accordance with the law. Appendices. Appendices are developed in much the same manner as the main body of the model code. However, the appendix information is judged outside the scope and purpose of the code at the time of code publication. Many times an appendix offers supplemental information, alternative methods, or recommended procedures. Information may also be specialized and applicable or of interest to only a limited number of jurisdictions. Although an appendix may provide some guidelines or examples of recommended practices or assist in the determination of alternative materials or methods, it will have no legal status and cannot be enforced until it is specified clearly recognized in the adopting legislation. Appendix chapters or portions of such chapters that gain general acceptance over time are sometimes moved into the main body of the model code through the code development process. For example, provisions for gray water recycling systems that were once located in Appendix O are now part of the non-potable water provisions of Chapter 29 of the IRC. Ref. R 102.5. Local and state laws. THEIRC is not meant to nullify any local, state or federal law, and in many cases, such other laws supersede provisions found in the Model Code. Careful consideration should be given to the interaction of the residential code with other codes and laws of the jurisdiction and the state during the process of adoption. Zoning ordinances, for example, may include more restrictive provisions on distances to property lines and between structures, permissible heights and areas of buildings, the number of buildings on a lot, and the specified conditions of use and occupancy of residences and accessory buildings. Other local ordinances impacting the residential code and construction may include those regulating public streets, stormwater management, erosion control, public and private sewers and private wells. State laws may override the building codes in matters related to energy conservation, manufactured and modular housing, and accessibility for persons with disabilities. State law also often determines the circumstances under which a licensed engineer or architect is required and sets the licensing regulations for these design professionals. Fig. UR 2-2. Ref. R 102.2. Authority. THEIRC establishes a Department of Building Safety, commonly referred to as the Building Department, and designates the officer in charge of the administration and enforcement of the code as the building official. The appointing authority of the jurisdiction appoints the building official, though jurisdiction job titles may vary. The building official in turn assigns some degree of decision-making authority to deputies, plans examiners, inspectors, permit technicians and other employees. The role of a building official in protecting public safety is complex and challenging. It follows that the position demands skills, knowledge, and abilities to not only fulfill the duties, but elevate the credibility of the department in the eyes of the public. Authority and duties of the building official. THEIRC charges the building official with enforcing the provisions of the code and assigns broad authority and discretion to do so. With discretion comes the responsibility to make decisions in keeping with the intent of the IRC. The building official does not have authority to waive code requirements. In the same way, the building official has no authority to require more than the code stipulates. THEIRC also authorizes the building official to develop policies and procedures for consistent application of the code provisions. Ref. R 104.1. In effectively performing the duties listed in the code, the building official must also have an understanding of the legal aspects of code administration. While given broad authority for enforcement, including the issuance of notices and orders, the building official must also recognize the rights of due process afforded to the public. Equally important to the building department in securing safe buildings for the community is to build the public trust through communication, respect, and fairness, so that the department is viewed as a resource rather than an adversary. Interpretations. Many code provisions are clear and easily understood. The diamond signs for stair rise and run, handrail height, and spacing for openings in guards, for example, are specific and objectively measurable. Such provisions are referred to as prescriptive, a clear set of rules to follow to gain compliance. The shape of other than round handrails, on the other hand, is less clearly defined. Although the code sets some parameters for dimensions of these handrails, it also permits any handrail that provides equivalent graspability. The term, equivalent graspability, is a performance requirement, meaning that an element must function to satisfy certain acceptable criteria. Determination of compliance requires some level of judgment on the part of the building official. Though the IRC intends to be largely prescriptive in nature, it purposely offers performance criteria as well, to allow flexibility in design and construction and to not favor certain materials or methods over any other. Alternative Methods and Materials and Evaluation Service reports the IRC is specific in its intention to not exclude the use of any material or method of construction, even if such methods are not specifically described by the code, subject to approval by the building official. The building official has not only the authority but an obligation to approve such alternatives where he or she finds that the proposed material or construction meets the intent of the IRC and is equivalent to the code provisions. When a proposal for using an alternative method or material is denied, the IRC requires the building official to state the reason for disapproval in writing. With modern technology advancing at a record pace, new and innovative building products are continuously introduced to the market on a global scale. Reports issued by the International Code Council's Evaluation Service (ICCS) are valuable resources in verifying performance equal to the code requirements. Figure 2 to 3. In the absence of ICCS evaluation reports and where insufficient data or documentation exists, the building official may require that tests be performed by an approved agency to demonstrate compliance with the code. Also, compliance with the specific performance-based provisions of the referenced international code satisfies the IRC requirements. Performance and alternative methods provisions of the IRC and the use of the ICC evaluation reports provide for flexibility and encourage innovative and new materials, design and construction while protecting the public safety. All published ICC evaluation reports are available free of charge and can be accessed online at www.iccs.org. Ref. R 104.11. Occasionally there are instances where it is not feasible to fully comply with the strict letter of the code. In this case, the IRC allows a modification of the code provision for individual cases when approved by the building official. The decision is based on documentation demonstrating that the modification complies with the intent and purpose of the code and does not lessen health, safety or structural requirements. The building official records the decision in the building department files. Ref. R 104.10. Permits except for a short list of work of a minor nature. Any construction requires a permit before work begins, including work for the relocation or demolition of buildings. Work exempt from permits must still comply with the applicable IRC requirements. Ref. R 105. Permit application. The owner or authorized agent makes application for a permit on a form furnished by the building department. In addition to providing a legal description of the property, the permit application must include the description of the work, the valuation of the proposed work, the use of the building and the applicant's signature. Figure 2 to 4. Ref. R 105.1, R 105.3. Plans and specifications, construction drawings and other submittal documents must accompany the permit application and be of sufficient detail and clarity to verify compliance with the code. The code also requires a site plan showing all new and existing structures with distances to lot lines. The extent of construction documents varies with the complex ITY and scope of the project. The building official is authorized to waive submittal documents for work of a minor nature, provided that code compliance can be verified by other means. Local or state laws determine requirements for a registered design professional to prepare the construction documents. In the case of any special conditions as determined by the building official, such as the sizing of a steel beam or the support for a concentrated load, the building official is also authorized to require plans to be prepared by a registered architect or engineer. Ref. R 106. A detailed review of plans and specifications is necessary to verify that the design complies with the code, thereby avoiding costly modifications during the course of construction. Jurisdictional policies differ in the handling of incomplete or incorrect plans. Depending on the complexity of the project and the significance of errors or omissions, the plan's examiner, on behalf of the building official, may furnish comments or a list of code requirements to the applicant, may request supplemental information from the applicant, or may reject the plans and require submittal of revised documents. Figures 2 to 5 and 2 to 6. Fees. The jurisdiction establishes a schedule of fees at a level sufficient to offset the costs of providing the associated services to the public, including administration, plan review and inspection. Permit fees are often based on the total value of the work included in the scope of the permit, though other methods may be used. In any case, the building official should develop an equitable and consistent procedure for assessing fees related to the permit process. Figure 2 to 7. Ref. R 108. Permit issuance. In the language of the code, the building official must review the application and construction documents within a reasonable time and, when approved, issue the permit as soon as is practicable. Figure 2 to 8. The length of time considered reasonable will vary based on several factors, such as the complexity of the project and the completeness of the construction documents. The intent of the code is to allow sufficient time for a thorough review of plans to determine code compliance and to issue the permit in a timely manner to avoid unnecessary delays in the construction schedule, resulting in hardship to the applicant. A copy of the permit and the approved construction documents must be kept on the job site until completion of the project. Ref. R 105.3.1, R 105.7, R 106.3.1. Permit issuance. In the language of the code, the building official must review the application and construction documents within a reasonable time and, when approved, issue the permit as soon as is practicable. Figure 2 to 8. The length of time considered reasonable will vary based on several factors, such as the complexity of the project and the completeness of the construction documents. The intent of the code is to allow sufficient time for a thorough review of plans to determine code compliance and to issue the permit in a timely manner to avoid unnecessary delays in the construction schedule, resulting in hardship to the applicant. A copy of the permit and the approved construction documents must be kept on the job site until completion of the project. Ref. R 105.3.1, R 105.7, R 106.3.1. Inspections. Inspection of the work by qualified personnel at various stages throughout the construction process is essential to verify compliance with the code and the approved plans. It is the responsibility of the permit holder or agent to call for the required inspections before work is concealed and to provide access to such work. If inspection reveals work that does not comply with the code, the inspector notifies the permit holder or agent of the deficiencies requiring correction. The inspector must approve the corrected portions of the work before they are concealed. When work is satisfactory, the inspector typically indicates approval with an inspection sticker or tag, figure 2 to 9, or by signing a record of inspections card authorizing work to proceed, figure 2 to 10. Ref. R 109. Required inspections. THEIRC specify Cali requires certain inspections during the course of construction when applicable, as set forth in Table 2 to 1. Ref. R 109. Other inspections. The building official is authorized to require additional inspections as may be necessary to ensure compliance with the code. Many jurisdictions perform insulation and energy inspections to verify compliance with energy conservation provisions. Inspections may also be desirable to verify the installation of unusual, special, or engineered components or systems. For example, a cast-in-place or precast structural concrete FL or deck, figure 2 to 11, is an engineered structure, the design of which is outside the prescriptive provisions of the IRC. The inspector must verify dimensions, materials, anchorage, reinforcing and other details to ensure conformance to the engineered drawings. Certificate of Occupancy. THEIRC requires issuance of a certificate of occupancy, figure 2 to 12, indicating that the work has passed final inspection before a dwelling unit, or the portion of the dwelling unit covered by the permit can be occupied. Ref. R 110. Board of Appeals. The Administration chapter of the IRC creates authority and duties for the building official but intends that actions in enforcing the code be reasonable, and also clearly expresses rights of due process for the public. Such is the case in the right to appeal an order, decision or determination of the building official. Any aggrieved party with a material interest in the decision of the building official may apply for redress to the Board of Appeals, figure 2 to 13. The governing body, such as the City Council, appoints the board members, who are qualified by experience and training to hear and rule on matters related to building construction. The intent is to put in place an objective and knowledgeable group of citizens to review the decisions of the building official and consider the merits of any appeal. The IRC limits the basis for appeal to matters pertaining to the code requirements. The appellant must claim that the building official has erred in interpreting the code or has wrongly applied a code section. The other basis for appeal is that the appellant considers a proposed alternative to be equal to the code requirements. The IRC does not permit the filing of an appeal seeking a variance or a waiver, and the board has no authority to waive code requirements. Ref. R112.